Hello, everyone, and welcome back to the lecture series for the preparation of CLAT examination. We've been talking about and discussing a lot of important legislations and areas which are going to be helpful while preparing for CLAT examinations as such. As of now, we have till now we have discussed about the constitution, we have discussed about the contract laws, we have discussed about the criminal laws now, and family laws to a greater extent. There are certain questions which we are going to discuss in future as well. But as of now, we have planned and decided that we will be moving forward with an important topic that is perhaps very important topic for discussion when we talk about CLAT examinations as such, because international law is one area where which we have seen that lots of questions has been asked, and the area from which the questions are being put up in your CLAT examinations are perhaps limited in scope. So there are particular areas which are going to be asked in your international law syllabus of your CLAT examination, focusing over the legal reasoning portion of your CLAT examination. So in international law, the scope is limited, and the questions that will be asked to you, depending over your caliber and the amount of knowledge that CLAT aspirant is expected to have, though the area gets limited, so the chances of the students scoring good amount of marks in international law while preparing for CLAT examinations is perhaps higher. And as you know that from the recent amendments that has been brought about by the CLAT consortium, now instead of 150 questions, you will only be getting 120 questions. In a span of 2 hours, you have to tackle 120 questions, meaning which you will be getting around 1 minute to solve one particular question. And that time, I suppose, is more than sufficient, because seeing to the pattern that has been altered by the CLAT consortium, it becomes clearly easy for the students to take time to understand the paragraph and to tackle the questions. But majority of the students might feel that sir, it is a good news, but I'll tell you, it is neither a good news nor a bad news for the students. The reason being, when you talk about CLAT, I suppose the screen is visible to everyone. So when you talk about CLAT examination, so in CLAT, the questions that will be put up in front of you will not be only confined to international law. If you talk about the legal reasoning portion, so the areas that will be asked from in the legal reasoning portion of your CLAT examination will not only be confined to international law. It will consist of constitution also. It will be from contract laws also. It will be from family also, and family law. Then you have law of torts that is there. So constitution, contract, family, tort, international law. Then you have criminal laws. And apart from criminal laws, you also have to deal with intellectual property rights. And apart from that, there are the Supreme Court judgments, which are important for discussion. And then obviously your Latin maxims. So when you see the syllabus of the legal reasoning portion of your CLAT examination, the student gets confused that, sir, we have to study constitution also, we have to study international law, contract, family law, torts, criminal laws, IPR, Supreme Court judgments, and the Latin maxims. So are we going to study each and everything, or are we going to limit the scope of the syllabus and just go through the important provisions? It is always advised that the student should first analyze the question paper and try to understand that from the previous year question paper from the previous year question papers, you will get an idea that what are the areas from which international law is being dominantly asked, what are the areas from which the constitution is being asked, then what are the areas from which the contract is being asked, and so on. So for you people, it is not the need, because that is where we come into play. We as mentors will make sure that whatsoever we are teaching you is actually limited to the scope and the syllabus which has been designed by CLAT consortium, so that the students are not studying everything which is related to international law. Because truth be told, international law in itself is a very lengthy topic, and there are debates, discussions, conferences that takes place, and it perhaps is another stream of law which people get expertise in, and they try to understand and try to figure out that what are the complexities, what are the problems, what are the loopholes in this particular law, and how the society is getting advantage from this laws, and what are the things that needs to be done in order to improve the laws which is related to international uh, conference, international relations, international bonds, etc. So first and foremost, the word international law, if you can keenly observe, has been made from two words. One is inter, and the second is national, and then obviously the law. So if you divide it into three portions and see through it that what exactly it means, so it means a nations, then you have interdependence, and then the laws which are going to govern these areas. This is, in short, what exactly is international. But now you might feel that, sir, this is something obviously we can understand by the splitting of the word international law. But what exactly do we need to study when we talk about international law? What are the things that is important? So first and foremost, that is according to your CLAT syllabus, the most important portion that we are going to study in international law is first and foremost, we are going to study about the United Nations. Now, United Nations in itself is a very lengthy topic, and it is an organization that was formulated post World War II. Post World War II, when after the World War, in the month of June 1945. I'm so sorry, it's October. We got an idea of United Nations, and there were initially some members who joined this organization, and they worked forward in order to provide an organization which is not dependent over any other nations, but which follows principles of peace and security, and fulfillment of brotherhood and integrity throughout the nations. It is not confined only towards one particular nation, but it is going to make sure that there is a peace, stability, and safety throughout the world. So the cooperation is needed by all the nations whomsoever are the part or the members of the United Nations, and they are going to work hand in hand in order to provide a better world for the upcoming generations, and to make sure that the current generations are getting what exactly their needs are, and the nations are working to the best of their caliber to make sure that the citizens are getting the minimum required amount of rights, and in the longer run it will help in improving the coordinated relations between the different nations altogether. So what exactly is the aim of the United Nations? Why was it formulated? How many members are there in the United Nations? What are the parts of the United Nations? Whether United Nations is only consisting of only one body, or there are different sub organizations which is behind it. All these things are important when we talk about the CLAT syllabus, and that is why United Nations becomes a very important point of discussion when you talk about international law. Apart from that, apart from United Nations, we are also going to study about World Trade Organization. The same organization, United Nations, is focusing over the peace and stability. World Trade Organization is ensuring that there is free trade and commerce throughout the world. Throughout the world. Then, apart from that, you have World Health Organization. World Health Organization, which is going to take care of the health of the humans and work for the betterment of the human health. So basically, when we talk about the World Health Organization, so World Health Organization, you know that 2020 we got struck by pandemic, and throughout the world there were lots of chaos and lots of problems. World Health Organization started researching and figuring out that what can be a vaccine or what can be a solution to fight this particular pandemic. And in the end of the day, we got the vaccine created, and which was given throughout the world, which helped us fight uh, the COVID-19 virus. So this was actually the World Health Organization who worked in cooperation and in collaboration with different nations and tried to figure out that what can be the best medicine which will help out in eradicating this particular disease from the world throughout. And still there are lots of research that is going on in order to improve the human health, and in order to make sure that whatsoever disease a human might face, they have uh, medicine, or there is a cure that is present. So that is what exactly is the World Health Organization. Apart from that, there is one more organization that is important for us to study, and that is IMF, which is known as International Monetary. So what exactly this organization does, what are the goals of this organization, each and everything are we are going to study in our international law. So starting, we will be focusing over what exactly is international law, how international came into being, when it started, what is the history behind international law, because the questions that will be put up in front of you when you talk about CLAT examination can be from the history of international law also. What exactly is the difference between a public international law and private international law is something that obviously a CLAT aspirant should have the knowledge, and will obviously be put up in front of you in the form of questions when you are going to give your CLAT examination. So long story short, let's start with the chapter. Let's start with the subject of international law and try to understand that what exactly is international law and what are the things that we are going to understand in this particular session. The first and the foremost thing, when you talk about international law, it says that international law is divided into two kinds. First is the public international law, and the second is the private international law. So now we got an idea that when you talk about international law, there are two subdivisions of international law as such. The first is the private international law, and then the another one is public international law. So what is the difference between a private international law and the public international law? The first and the foremost thing is that is need to be understood. So when you talk about international law, and we see through it that there are two divisions, one is being the private international and the public international law. The main difference lies between the scope of their implementation in regards to the law, where that law is going to be applied. When you talk about private international law, the law has been confined over to a particular nation itself. If we talk about the Constitution of India, which is being governed only in regards to a particular nation or particular country, and it will not be applicable to the Constitution of India shall not be applicable to the Republic of China or Pakistan or Sri Lanka. They might be having a different law as such. But main principles, the main principle, underlining principles, for example, providing the rights to the citizens, providing basic amenities, for example, food, shelter, and clothing to the citizens, giving them right to vote if the nation is a democratic nation. All these principles, which are actually being understood, are that they are the part of the private, they are the part of the nation's governance as such, is actually being governed through international law. So that is why whenever you will see different nations laws that are being governed, you will see some sort of similarity between every nation. Every nation will have some sort of similarity in that particular concept, and that is why private international law is that law which is only governing the particular nation as such. Let's try to understand what exactly has been mentioned in the private international law here. It says that it is also known as the conflict of laws. Now, this is important for you guys. Why is it important? Because when you talk about CLAT, so CLAT is not going to ask you questions very deep inside, because obviously, as a law student, as a law aspirant, I would say, you are not actually supposed to understand what exactly uh, is in-depth meaning of private international law. But you should have a little bit of idea that what exactly is the major difference between a public international law and a private international law, or rather, how many divisions are there of an international law, and what exactly is the other name that is being used for a private international law or a public international law. So the questions that will be put up in front of you shall not be that what exactly is the difference between a public international law and private international law, but there can be a question that will be saying that what is the difference between the conflict of laws and public international law. And this is the point. This is the point where the students gets into confusion. They feel like that we have studied the difference between private international law and public international law, but we haven't studied the difference between the conflict of laws and public international law. And they tend to answer, either they will tend to leave the question, or they will skip the questions, or they will end up marking a wrong answer. And that is why it is very important. It is perhaps very essential to understand that a public international law and private international law, which is also called conflict of laws, is rather almost the same, meaning which it can be interchanged. By conflict of laws can be used in place of private international law. Private international law can be used in the place of conflict of laws. So now once you have understood it, if somebody will ask you that what is the difference between conflict of laws and public international law, now you have an idea, you have a clear understanding that it is the question is that is being put up in front of me is what is the difference between private international law and public international law. So it becomes easier for the candidates, for the students to understand it and to answer it. And that is why these information, whichever has been mentioned in front of you, becomes important for your CLAT perspective. When you talk about private international law, it says it is also known as the conflict of laws, and it is essentially refers to which countries law should be applicable to a particular dispute. It is usually deployed by the domestic courts of the country. It is usually deployed by the domestic courts of the country. So it becomes important for your understanding that whenever there is a dispute which arises within the nation, at that point of time, those laws which are going to be applicable in resolving the dispute will be considered as private international law or the conflict of laws, or there is one more word that is being used here, and that is municipal laws. Municipal laws is also the name that has been used for private international law. Let's move forward and let's try to understand what exactly is public international law then. So public international law says that it governs or it concerns the structure and the conduct of sovereign states. Now, what do you understand by sovereign states here, guys? Sovereign state means states who has been recognized, who are recognized by other nations, that yes, this is one nation, and they have a government, and that government has supremacy. And when you talk about these things, that there is a sovereignty, there is one supreme power or supreme head, with the government being the supreme head, and it is recognized by the other nations. That is actually called sovereign states. Example could be India, China, America, or any nation which you feel comfortable, and you understand that yes, this is a particular nation or a country which has been recognized, and you see it in the map on which the whole world is being mentioned and mapped. All those states which has been recognized are known as sovereign states. And intergovernmental and international organizations. So, public international law is not only confined towards the sovereign states, meaning which the relation between India and China, that is only not the concern of the public international law, but rather that if India has a relation with WHO, World Health Organization, or India has a relation with the United Nations, or India has a relations with IMF. So all these type of intergovernmental and international organizations, whenever there is structure and concerns on relations between the nations, the sovereign states, the international intergovernmental organizations and international organizations, then that type of governance or that type of laws are known as public international law. I suppose you have been understanding the difference between what is public international law and what is private international law. Now let's try to summarize and understand what exactly is the difference here. It says that public international law, if we talk about public international law, it is a relationship between states. Public international law, that has already been understood. And private international law is international relations between private parties. So international relationships between private party means, for example, if there is a country being China and uh, any company with the name of Chinese company is manufacturing something in India, okay, and there is a dispute that arises between that company and the government of India. So government of India. So if there is a dispute between the government of India and the company which has been manufacturing in India itself, but it belongs to China, so there are certain laws. Obviously, the domestic laws will come into play because the company in itself is situated in India and they are manufacturing the products in India itself for India only. But there are certain rules and regulations where which obviously China will also come into play because the company is of China. So the other nation will obviously make sure that if our company is being manufacturing something in another state, we should make sure that those rights are not curtailed. So whenever there is this type of conflicts that might happen, public private international law comes into play. And even if you talk about domestic laws like the constitution, the contract, all these laws are going to be governing these type of disputes where which there's a company or there is an agent or there's a representative of one nation which has conflicts within the nation of the other country, and the dispute is being resolved through what we call as private international law. Now moving forward, let's try to understand what exactly is the history of the public international law. When we talk about public international law, it says that although international law in the modern sense of the word has only existed since about the 16th century. So the first important point here is that the international public international law got recognition from the 16th century onwards. Many historians of the international law also take international law also take ancient history into account as a source for the early development of international legal principles. So let's try to understand that what are those ancient history or the sources for which the international law actually got derived from. Let's try to understand it. It says that the first and the foremost is the Roman laws. Roman law concept of inus civile, inus genitum. In that respect, important concepts are being derived from the practice of the practice between Greek city-states and the Roman law concept of ius civile, which regulated the relation between the Roman citizens mutually, and ius genitum, which regulated the relationship between the Roman citizens and the non-Roman people. Okay, so if you talk about this maxim, which is there, it is nothing. It is just telling us that when we talk about the Roman laws, Rome was considered to be a much more developed nation, and all the major philosophers and the thinkers obviously comes from this particular place of Greek and Rome only. So at that point of time, the philosophers and the the theorist actually worked out, and they provided a concept that there is laws which is going to govern the relations between the civilians of that particular nation, and there will be another law that is going to govern the relation between that nation, that is the Roman citizens and non-Roman citizens. So when you talk about there is a difference of laws, so you see that there is no uniformity here, but there is a difference on the basis of one nation, and uh, amongst the nation, whatsoever the people are there, they have a different law, that is INS civilly. And if there are other people coming from another state, okay, they are another state, and if there is a relation between these two people, then it is going to govern through another maxim, which is genitum. So you see, from the ancient history itself depicts that there was a formation of two different type of laws, depending on whom are they going to be applied. So the applicability played an important role in evolving the concept of public international law way before the current laws has been framed. So from the earlier 16th century itself, you see that from the Rome, the concepts of ins civili and ius genitum has taken out, which says that if we are talking about governance of law within a particular nation or within a particular people, or people belonging to the same country, Roman citizens mutually, which regulated the relations between the Roman citizens naturally, and that is what is ius civilly. And the relation between the Roman citizens and non-Roman people, it is ius genitum. So there is a difference in approach and applicability of the laws for different people at different point of time, which gave a concept of a different type of laws, one being the public laws and another being the private laws. Okay, that is how the concept is actually evolving. So the very first thing was from the Roman laws it came into being. Then Hugo Grotius, important name, and you should also remember that what exactly this particular author or the philosopher has provided, because these books, whatsoever titles we are going to discuss in international law, these books might be put up in front of you, right in front of you, and there will be questions that will be put up like, who has written this book? So if you see this example, De Jure Belli es Paces, this is the Latin maxim which treatise titled De Jure et Paces, authored in 162, 16th century we are talking, marks the beginning of the modern theory of international law. And Hugo Grotius is also considered to be the father of international law. So these are the small things and the important portions that you should remember when you talk about international law as such. That the questions that will be put up obviously will be asking you that who is the father of international law, and there will be 4 points that will be given in front of you. That one being Hugo Grotius, then there will be Salmon, then there will be Aristotle, and then there will be Bentham. And you will be asked that which is considered to be the father of international law. So you need to be very clear that when you talk about the international law, the public international law as such, it is the Hugo Grotius who has been considered as the father of public international law. Okay. So this is the book. This was Mr. Hugo Grotius, who has who has made this book, De Jure Bellis es Paces. I am so sorry, but I might be wrong in the pronunciation. But for you people, it is not about the pronunciation, rather the concept and obviously the author of this particular book. So Hugo Grotius wrote this book, and it dealt with the laws of war and peace. So how the laws of war and peace should be governed, it is mentioning about that particular book. So in that book itself, Hugo Grotius has mentioned a lot about how the international law should be, what exactly the international law should look like, what exactly is the need of the international law. So in relation, in contrast to the wars and the peace, Hugo Grotius has tried to explain what exactly public international law can be. Okay, so moving forward, it says Peace Pact. Beginning with the Peace of Westphalia in 1648, where several Europe nations signed a peace pact that the concept of sovereign nation state, which consisted of a nation controlled by a centralized system of government, gained a fillip. The existence of several nation states implied the necessity of a body of rules which governs the conduct amongst them. Okay, so now what happened in Westphalia, that in 1648 several European nations, okay, you must have heard about the European Union. Okay, so this was the beginning of international law, and the evolution of the international law started from these small incidents that are taking place and which we are discussing as of now, which actually help in evolving the international law as such. So what happened in 1648, that in Westphalia there were different European nations who put forward and they made up a concept of sovereign nation state, where which different nations come together and they provide a centralized system of governance throughout the nations. And the existence of several nation states implied the necessity of a body of rules which govern the conduct among them. So if you have seen Europe, so if you talk about Europe, there are different nations that are there. So these nations, they decided that they will have a centralized system where which they all will be governed almost a same manner, in order to ensure that there is a peace and stability, and we are working towards upliftment of the people as such. So this was how it started, and it helped in understanding and making the international law. So two main branches are there. The field of study in international law have two main branches: the law of nation, that is jus gentium. It means the laws that is going to govern in between the nations or intergovernmental organizations, and international agreements and conventions, jus inter gentes, which have different theoretical foundations and should not be confused with. Now, the first is the law of nations. When you talk about the law of nations, it means there is one country, India, then there is one other country, America. Now, they have certain laws. They have certain laws. Now, these two nations wants to have a cordial relations for peace and stability. If we talk about the laws that are going to be governed between these two countries, obviously there can be various methods by which the laws can be made applicable. The first is following the international laws, the uniform laws. For example, human rights. Okay, so human right is a concept where which every human should have a minimum amount of standards and living, which will be helpful for them for their growth and foundations. And this type of things is known as laws of the nation. Every nation will have these particular laws. So that is jus gentium, which is applicable throughout the different nations, and every nations will have that particular concept in their laws. Then you have international agreements. Now, for example, India, China, USA decided that it is for their benefit and growth that if we all three can have a tri-party agreement. Tri-party means that there are three nations involved. Tri-party agreement where which we will help each other in education sector, and we will make laws where which some citizens of India can help growth in China, and in return China will provide amenities to India, and USA will also be having a relation with India, which will in return there will be some consideration that will be paid from India side to USA. So all these comes under international agreements. Now international agreements are also there. International agreements means that there are a group of nations who have decided that they have formed a contractual obligations over each other, that we are going to follow this for a particular scheme, for a particular growth. So when you talk about the difference between law of nations and international agreements, so international agreements will be confined over a particular thing only. For example, education, for example, health, for example, growth, for example, infrastructure, for example, conservation of the environment. So these are international agreements. And laws of nation is uniformly applicable. So this is a major difference between international agreements and law of nations. And you have conventions. Conventions is perhaps almost the same between the international agreements and the conventions, but there lies a small difference, which is when you talk about conventions, conventions are things which has been followed from a longer period of time. And it is through those conventions only, through these conferences only, that two nations have mutually agreed upon to follow particular regime for their upliftment, for their growth, and for the growth of their citizens. So there are different fields of study in international law. The main branches gets divided into the law of nations and international agreements and conventions, which should obviously not be confused with. So I suppose you have understood the difference between jus gentium, international agreements, and conventions, which is known as jus inter gentes. Let's move forward. The sources of international law are customs. Now we are talking about the components. What are the components of international law, meaning which from where the international law gets the source? What exactly can be the source of international law? So when you talk about the source of international law, the first and the foremost source is known as customs. So whatsoever has been happening from a time immemorial, we will utilize, we will see through it that if there are certain things that obviously needs to be followed, that the custom, in order to have the custom to be a valid custom, and I suppose we have already studied in our past videos that how a custom can be considered to be a valid custom in our family law, in our contracts. We have studied about the valid custom, so you can refer that video if you want to understand what exactly is the meaning of a valid custom. But here, if you're talking about the sources of international law, it is assumed that if you're talking about custom here, then custom by means, any means a valid custom. A treaty. Treaty means there is an agreement between two nations to follow a particular regime or particular way, that is treaty. And general principles of law. General principles, jus gentium, that we have studied just before. This would include some of the principles recognized by in the domestic laws of the nation. Say, for example, the recognition that a company has a separate legal entity, existence, equity, and good faith, etc. For example, idols. You know that in India, we follow idol worship, if we talk about Hinduism. So this concept of idol worship is not only confined towards India. That idol who is being considered as a god or goddess is also a legal entity. This concept is not only followed by India, but universally it is being followed, that if there is anything which is considered to be an idol and people are worshipping it, then it will be considered as a legal entity. So the general principles which is being recognized, I just told you in the very beginning that there are certain laws which you will find mentioned in almost every nation, whether it is about the fundamental rights, whether it is about the formation of the government, whether it is about the recognition of a legal entity. Everywhere you will be finding the same principles, and those principles, when you talk about, are actually the sources of international law, which shows that if this particular country or some particular country has been following the particular concept or the principles, then it is a uniform applicability, and this constitute the sources of international law as such. Let's move forward and let's try to understand what exactly is other important point is. Further, there are separate set known as subsidiary sources. Okay, subsidiary sources which are opinion of judges. Okay, so the precedents. We're talking about precedents here. We are talking about precedents. In prior cases, an opinion of eminent legal scholars as mentioned in their writings. So it is not only about the precedents, but the commentaries of scholars in their different fields, which also provides a source of international law. So the sources, I suppose, should be clear, because there might be some question that will be put up in front of you as form of source. Treaties, as I've told you, is the source of international law. Then what exactly is a treaty? Treaty are of two kinds. There can be bilateral treaty and multilateral treaty. Bilateral treaty means, bi means two. So if there are two nations who have make a treaty, bilateral treaty is one concluded between two states. Okay, that is what I've just told you. Only, and is also known as a treaty contract. Double taxation agreements are generally bilateral agreements, meaning which India and China had an agreement for sale and purchase of cotton. So it is confined only between India and China and no third nation. So there is no involvement of third nation here. That type of agreement and that type of treaty is considered to be a bilateral treaty. So you need to understand the concept, because the concept, once it is clear, you will be able to clearly understand that how the things are. Now, after understanding bilateral treaty, let's try to understand what is multilateral agreements or multilateral treaties. It says multilateral agreements are agreements entered into by several nations, such as the United Nations agreements. Okay, so United Nations Charter, we are going to study that. So it is what? It is a treaty that has been signed by multiple nations. Multiple nations which have the same intentions and same need, and that is why all the nations came together and they formulated a particular agreement. And this type of agreement, which has been formulated by the multiple nations, is known as multilateral treaty. So first example, United Nations agreement, the International Covenants of ICCPR, civil and political rights, which provided the human rights, and International Conventions of Economic and Social Rights, ICESR. These two organizations worked and formulated the importance of human rights. The Refugees Conventions, the Conventions on International Sales of Goods, CISG, and the agreement establishing the World Trade Organization. So World Trade Organization, I've just informed you that we're going to study. All these examples are the examples of multilateral agreements. Moving forward, the one and the most important treaty is the Vienna Convention on the Laws of the Treaties. In the same way as the provisions of any contract in India are to be interpreted in accordance with the Indian Contract Act of 1872, treaties are to be interpreted in accordance with the Vienna Convention on the Law of Treaties, 1969. Okay, so I suppose it is self-explanatory. The conventions enter into force on 27 January 1980. The Vienna Convention on Law of Treaties has been ratified by 110 nation states as of October 2009. And obviously now it has been increased to a greater extent. So whenever there is any country who is signing the Vienna Convention, they are agreeing that they will make treaties, either bilateral treaties or multilateral treaties, depending on the procedure that has been laid out under the Vienna Convention of Law of Treaties that has been mentioned under 1969. Okay. Then what after that? We have understood what exactly the treaties are. We have understood that how the treaties actually come into play and what exactly the treaties are in regards to international law. The international law have different sources. Some of the sources are customs. Another sources are the general principles recognized by the different nations. And then you have treaties. Treaties can be bilateral treaties and multilateral treaties. Examples of bilateral treaty I've just explained you that if there is a nation if there is a agreement between India and China, and they want to establish a agreement between them for that particular product which being exported from India, China in return is going to give something. A bilateral treaty. Multilateral treaty, majority of the nations, major nations or multiple nations come together to have a same goal, and in order to fulfill that goal, they form an agreement that we are going to do this in order to achieve the main goal as such, which is going to be beneficial for all the nations who are among the agreements, who have made this particular agreement are going to be there. So in the same manner, there is one other union that was formulated, which also helped in the evolution and understanding of the international law, which is the International Telecommunication Union. While rules governing the conduct of independent nations interstate continued to evolve, it was not until the late 1800s that a separate international organization consisting of various nations as its member was formulated. And this nation is known as International Telecommunication Union. So this also helped in the formulation. What exactly it was, let's try to understand. The International Telecommunication Union is the eldest organization in the United Nations family still in existence. It was founded as the International Telegraph Union, okay, as on March 1865, and is today the leading United Nations agency for information and communication technology issues and the global focal point for governments and the private sectors in developing networks and service. Okay, so this is perhaps an agreement which is also a form of a multiple trade agreement, telecommunication agreement. Now again, you have Universal Postal Union. This is another example. I suppose that is not very much important, so we can skip the part and let's move forward and try to understand what are the other important portions. Yes, you can just give a superficial look and you can just read it out, the points, what exactly is Universal Postal Union. I can just bring it back so that you can just read it out. You can pause the video and you can read it out and then you can move forward with the same. Not very important, but yes, you might be asked some factual questions from it as to the organizations, where is the headquarter of Universal Postal Union. So you should know actually where is it. Then you have United Nations. So as we already know that now when we talk about treaties, which are the sources of international law, whenever there is a group of nations who come together to formulate a law or the treaty which gives rise to a source of international law. So international United Nations is perhaps the best example of the multilateral treaties, where which it instituted and started way back in 1900s, and from that point of time there are more than 190 countries who have been a part of United Nations, and all these nations whomsoever are the part of United Nations have followed the principles and policies which has been formulated by the United Nations and its members. And that is why it becomes very important as a CLAT aspirant, as a student of law, to understand how the evolution of the United Nations takes place. So we are going to study this. So please be very careful that what exactly are the things that has been mentioned, and you need to grasp these information. These are factual informations. I know sometimes it becomes difficult for you to retain these information, but yes, it is also perhaps important to remember this. So that is why I would request you all to grasp the factual information and try to understand the concept as to how the evolution of United Nations took place. Okay, so the name United Nations, who has devised this, was divided by the ex-United States President Franklin D. Roosevelt. Very important point here. Very important. That is, who devised the name United Nations? It was Frank D. Roosevelt who gave the term United Nations, devised by the ex-United States President Franklin D. Roosevelt, and was used in the Declaration of the United Nations, meaning which the formulation of United Nations started at this point of time, and on of January 1942, during the Second World War. The World War was still going on. If you remember, 1939, 1945. It is the time of the Second World War, when the representatives of the 26 countries pledged their government to continue fighting against the Axis power. Okay, so representative of 26 countries, they pledged that they are going to fight against the Axis power, and this is how the formulation of the United Nations came into picture. The United Nations is the hope and the conscience of the world, more especially of the smaller nations among the 190. Now it is, instead of 192, is 194 in 193. Just check. We'll just check the factual information. It is 193 or 194. I'm a little bit confused, but to the best of my knowledge, it is 193 only. South Sudan being the last nation to join India, the United Nations. It is an association of states. Okay, let's try to understand what exactly United Nations is. It is the association of states, meaning which there are multiple nations coming towards and pledging towards a particular objective, which has pledged themselves to maintain international peace and security and cooperate in solving international politics, economical, social, cultural, and humanitarian problems toward achieving this end. Okay, so this is the major aim major aim of United Nations. We are going to study United Nations in detail. This is just a factual information for you, because majority of the questions that will be there in your CLAT examination shall be, if you talk about international law as such, it will be confined towards the United Nations only. So in detail also we are going to study, but for your understanding, we are telling you that the main object of this association of the formulation of United Nations was what? Is what? To maintain international peace and security, and to cooperate in solving what? The problems which is in relation to international politics, economic, social, and cultural and humanitarian problems towards achieving the same goal. So this was the reason for formulation of the United Nations. The United Nations Charter, okay, it is the laws of the United Nations. The constituting instrument of the United Nations was drawn up by the members of 51 countries. Okay, 51 countries made this particular United Nations Charter, the United Nations Law, at the United Nations Conference on International Organization, which met in San Francisco from 25th April 1945 to June 26, 1945. So 51 countries. Just imagine, if you're talking about multiple treaties, multilateral treaties, then not one, not two, but more than 50 countries came together. They sat together and they formulated the United Nations Charter. So if we compare it with India, you can get an understanding that when we united India, for initially India was nothing but a dominion of different states. There were more than 540 dominions. Then it got concentrated and it formulated into different states: Uttar Pradesh, Madhya Pradesh, Maharashtra, and Kerala. So different states were formulated, and then all those states got unified, and they provided and they said in their constitution that we the people of India has been solidly resolved. So now it is Indian altogether, which has been formulated by different dominions. They came together and they said that yes, we are going to adopt, enact, and give to ourselves this constitution. And based on the constitution itself, the whole the structure of the country is being governed. So in the same manner, if you go to the international concept, the United Nations follows the same. It is following the same formula, or perhaps the same philosophy, that different nations, here it is a bigger picture, different nations are coming together and they are confining themselves. They are mutually coming to an understanding that we want to have a common ground or a common organization which is going to help in the peace cooperation and for the upliftment of the people. And that is how United Nations Charter came into being. The first meeting of this organization was held in San Francisco from 25th April to June 1945. Factual information, but it is important for you to remember. Those delegates deliberately, on the basis of proposal worked out by the representative of the China, the Soviet Union, states at Dumbarton Oak, Washington, D.C. from August 21, 1944 to September 28, 1944. The charter was signed on June 26, 1945 by representative of 50 countries. Okay. Then there was 50 countries have signed this one. Poland, which was not representative of the conference, signed it later and became one of the original members of 51 nations. So it is important which nation had signed it after the creation of United Nations creation. So it was Poland. Important factual information, because these type of questions might be there in your question paper with your CLAT examination, that which country was that country who was originally the member of the United Nations, but it signed the United Nations Charter afterwards. So it is Poland. Poland is the right answer. Now, the United Nations officially came into existence on which date? Important for you. Okay, I suppose it's not working. Let me check what exactly is the problem here. Yes. So United Nations officially came into existence on October 24, 1945 with the deposit of the requisite numbers of the ratifications of the charter with the United States Departments of the State. So different countries formulated, and the existence of United Nations came into being from October 24th, 1945. Very important information. The date on which United Nations came into being is October 24th, 1945. There must be a question where which there will be 4 options that will be given to you. First being the United Nations came into existence on 24th of June to 1945, 24th of October 1946, 24th of October 1945, and then there will be another options. So you need to be very specific. You need to remember this, the factual information that is put in front of you, that it was on 24th October 1945 that the United Nations officially came into existence. Okay. Charter with the United Nations Department is celebrated on 24th of October. Correct? We have already understood it. Now, new member states are admitted by the General Assembly. Now, what are the organs? When you talk about organs of the United Nations, perhaps it can be mentioned as the first organ being the General Assembly. Okay, General Assembly, meaning which all the nations, whenever they get admitted to the United Nations Charter, they are the members of the General Assembly. Then there is Security Council. Security Council is also a part of United Nations. Apart from that, there is ECOSOC, Economic and Social Council. Then you have Trusteeship Council. Trusteeship Council means that if there is a nation that is being developed and it is very inferior, meaning which they are not able to get to the upliftment where which the developed nations are there. So any developed nations helps that nation in order to grow that, in order to develop that nation, and that nation is considered to be under the trust of the developed nation, and that is how the Trusteeship Council works. And that is also we're going to study, but just a general application I'm explaining you here. So first is General Assembly, second is Security Council, third is ECOSOC, fourth is Trusteeship Council, then you have the International Court of Justice, the ICJ, and then you have the Secretariat. All these organs of the United Nations we are going to study in detail, but let's try to understand the factual information that has been provided. So I suppose this information you have already read. I don't want to repeat it again because it will be a wastage of time. Then when the other nations came into being, this is the information that has been provided here. So you just read it out for your better understanding, and factual information can be done. Then Vatican City is a permanent observer. This is important information. It is a permanent observer. What exactly is a permanent observer? What exactly is a non-permanent observer is a question that should be put up in front of you, and you should be able to answer it. And this is your homework. Try to understand and try to figure out what exactly is permanent observer meaning. Second, how many official languages are there? There are 6 official languages in United Nations. That is, first is Arabic, Chinese, English, French, Russian, and Spanish. Very important. Very, very, very important for your CLAT perspective. When you talk about official languages, has been multiple times asked that out of the following, option number A, B, C, and D. Option number A, B, C, and D. Which language is not the official language of United Nations? So you need to remember it is Arabic. First Arabic, second is Chinese, third English, fourth French, 5 Russia, 6 Spanish. So you can remember it like this: A, C, E, F, R, S. Okay, A, C, E, F, R, S. So this is a mnemonics that you can use: A's, F, R, S. Okay, A's, fundamental rights, security. Okay, just giving an example for your better understanding. You can use the mnemonics, so you can use your own story in order to remember this. That A's, fundamental rights for security, or A's whatsoever you can make, and you can utilize it. But this is just my way of retaining the information, because sometimes it becomes impossible to retain everything, and that is the main goal of your examination. You've been asked to prepare in such a manner that there is a vast scope of information, and you need to remember the important informations as such. So this is a very important factual information, that there are 6 official languages: A's, FRS, where which you can remember A stands for Arabic, C stands for Chinese, E stands for English, F stands for French, R stands for Russian, and S stands for Spanish. Now about the flag. The flag of the United Nations has been embedded of United Nations in white, centered on the light blue background. Okay, so there is the flag seems like this. that you have the United Nations symbol here, like this. Okay, and the background. If you talk about the background, it is a light blue background in back. Okay, and in the center there is the emblem of the United Nations, and the United Nations headquarters is situated where? United Nations headquarters is situated in New York. This page or this slide is perhaps very important for you because it is giving you four important informations as such. Where is the headquarters? It is in New York. What is the symbol of the flag? Light blue background, white centered emblem. How many languages are there? There are 6 languages. What are those languages? ACE, FRS. Then, which is the permanent observer of United Nations? Vatican City. What exactly is the permanent observer? This is something that you need to remember. So, guys, I suppose you've been able to understand that how exactly the international law is it has such a wide scope, and it obviously we can take a lot of time in details in discussing what exactly is a permanent observer, how only 6 official languages are there, why is it so that Hindi is not there. So all these information and debates and discussions can be there, but when we are preparing for CLAT examinations, we will only be limiting our scope to the important information which will be helpful for you for your preparations as such. So let's try to understand the important aspects which will be helpful for your CLAT examinations. This will be it as of now. This is the first General Secretary of United Nations. Now, who is the current secretary? That is something that you should figure it out. Current Secretary of United Nations. And his name starts from A. Okay, a hint for you. So please try to figure out who exactly is the current Secretary General of the United Nations and from which country he belongs. Okay, so this is your homework. And then from next lecture onwards, we will be focusing over the different organizations of the United Nations organization, and the United Nations and its parts. Okay, the bodies of United Nations. We'll be studying about the Security Council. We'll be studying about the General Assembly. We'll be studying about the Security Council. So what is Security Council? Then we'll be studying about Economic and Social Council. Then we'll study the Trusteeship Council. Then we'll study the International Court of Justice, also very important. Then we will study how the presidents are there. Then we'll study the Secretariat. What exactly is the Secretariat? Then we'll be discussing about the International Criminal Tribunal of... this is also important. Not that much important, but yes, it is a little bit important because there were questions that was put up, I suppose, 2019 or 2020, which was in relations to the International Criminal Tribunal for Rwanda. So this is also important. Perhaps International Criminal Code is important, an important topic for discussion, that what exactly is International Criminal Codes and how is it different from International Court of Justice. We are going to study this particular point also. This is also an international organization. So there are different treaties. I told you in the very beginning, the multilateral treaties. So because of these multilateral treaties, these different organizations are being created. And these organizations have a specific role. When you talk about United Nations, it has various roles. But when you talk about these particular organizations, they have specific roles. When you talk about international criminal courts, so it is only confined towards the criminal actions that has been taking place and when it is involving 2 nations as such. Then you have Special Tribunal of Lebanon. That is also we're going to study, but not in detail. Post that, we are going to study about the famous international jurists and the book authored by them, because this is something which you will only be retaining it and memorizing it, because once you are able to memorize it, it will be easier, because there is something which obviously I cannot make you understand. These are name of the books and their authors, because sometimes you will be finding questions which the name of the book will be mentioned. A little bit of description obviously will be there, and then there will be questions that will be put up in front of you, that who is the author of this book. So that is why it becomes important to go through the name of the books, which is going to be very much helpful for your understanding and for your better approach. These are the different name of the books. Then we are going to study about World Trade Organization, a very important concept, and what are the different concepts that is applicable, what is GATT, all these informations we are going to study in our upcoming videos. So with that, I would like to end today's lecture session, because we have talked a lot about how the United Nations is being formulated, how the international law is being governed, what was the history behind international law, and how the evolution of international law is taking place. We'll be continuing with the parts of the United Nations and what exactly needs to be understood and what exactly these organs are uh, related to. That is something we're going to study in our upcoming lectures. But still, so far, I would like to request you one thing again. The same thing which I've been asking you from time immemorial, that please make sure that you are constantly revising whatsoever we are studying so far. Because in the end of the day, once you have understood the concept and you're not revising it again and again, you are, it is clear, and it is bound to happen that you will forget the concepts, and in the later end it will be difficult for you to recall it when you're going to give the paper. So it is important that you, again, I'm telling you, and I suppose that now majority of the viewers whomsoever are there will understand what this 3P means. So I would request you again to follow the 3Ps, that is the principles that we have studied, then practicing the previous year question papers, the mock papers, and being persistent. You follow the 3Ps, I guarantee you, you're going to crack your CLAT examination. With this, I would again like to thank you all for being present in this video. We will be meeting again in the upcoming video, which is only going to be in relation to the international law itself. And we'll try to understand and analyze that how the international law and United Nations organizations parts has evolved and has provided a better approach in regards to the international relations and the evolution of international law as such. With this, thank you so much, guys, for being present in this video. Take care. Bye-bye.